talking about different things that are happening at the Supreme Court. There was a decision made today that directly comes out of Illinois. In fact, a Republican congressman was challenging this issue of ballots, mail-in ballots being counted days, weeks after the election. In fact, here in Illinois, you have 2 weeks. I mean, as long as it's postmarked by Election Day, you still have some time on the opposite side of that to make sure that your vote is counted. And so he was challenging that. Obviously, it made it all the way up to the Supreme Court. Initially, it was thrown out. So now it's mainly saying he can continue on with his legal challenge, not whether or not his challenge has merit, but that he can continue on at least with the challenge. I want to bring in our first guest right now so that we can talk about it. T. Russell Noble is a Judicial Watch senior attorney, a part of Judicial Watch's voting integrity efforts, and focuses on campaign and voting issues, civil rights issues, constitutional law, official misconduct by public constituents, and so much more. So thank you so much for your time.
Thank you for having me.
What was your reaction to the ruling today?
We were very pleased, frankly not very surprised. For most of 200 years or 250 years, federal courts have always heard challenges brought by federal candidates over rules governing their federal elections. Suddenly in 2020 it became a new issue where people doubted whether or not federal candidates could bring cases in court to challenge electoral practices. And sort of been a non-event until 2020, 2019. And so this new this ruling today basically just returns us back to the way the world was in 2019. So very pleased, but not surprised.
Mm-hmm. And really, you know, Representative Bost is who we're speaking of here. It says that this all points to election integrity. Is that how you see it as well?
Yes, it deals with election integrity, and then also just honestly election legitimacy, right? Having so the long question here, as you mentioned in the opening, is that ballots can continue to arrive 14 days after Election Day and be included in the count. And the problem with that is now there's so many ballots arriving after Election Day that is really starting to undermine the confidence in the election, because when you go to bed at night, there's 150,000 votes, and you wake up in the morning and suddenly there's 250,000 votes. And then 3 days later, it's 350,000 votes. And so it's really corrosive to the democratic process to keep adding to the denominator of votes out there. So, I mean, obviously it's an election integrity issue, but it's also an election legitimacy issue. And, you know, in track and field, you have a 100-meter dash. In baseball, you have 9 innings. In football, you have 4 quarters. And in elections, you have Election Day. And that's the deadline. And that's our view. And we're looking forward to having federal courts answer the question why ballots can be received after Election Day, because frankly, this is sort of a new practice. It has been experimented with over time, almost always abandoned. But in the last 15 years, there's been some long national, frankly, nightmare to extend Election Day days and weeks past Election Day. So we're looking forward to getting the courts to give the good people of Illinois an answer as to why we need to conduct elections this way, because frankly for 250 years there was very little problem having ballots due by Election Day.
Yeah, and there were a few things that the Representative Bost pointed out here in his argument. One is that obviously this is what we do in Illinois is different from the federal law.
Yeah, so just to sort of back up, the federal government established a national election day in 1845, and then Illinois, for most of its history, mandated ballots be due by Election Day. And then I think maybe 2005, 2013, there's 2 statutes in play. I can't remember which one occurred first. I think it's 2005. Illinois switched it to start allowing post-election receipt. And that law is our contention, and we won actually in another court elsewhere, conflicts with the federal election day because federal election day statutes, because a ballot is not completed until received by the federal officials, or excuse me, the election officials. So if you mark a ballot in your home and it sits on your desk, on your counter in your kitchen, it's not a cast ballot. It can be lost in the mail. it can be changed in some states. And frankly, under the postal regulations, you can call back your letter. So if you mail something and you wanted to vote for President Trump and then he does something in the intervening time and he makes you mad, under the postal regs, you can literally recall that. Now, does that happen frequently enough to change the outcome of elections? Possibly not. But the thing is, a ballot is not completed until received by election officials. And so our view is that conflicts, the Illinois law conflicts with the longstanding Election Day statutes.
So Justice Brown Jackson and also Justice Sotomayor said that this opinion could destabilize the elections process by inspiring more litigation. What are your thoughts on that?
We respectfully disagree. I haven't gone through their 20-page dissent. Now, bear in mind, this was a pre-election suit. There are different issues that arise in post-election suits. I think that issue has been conflated. And so, when you bring a challenge to electoral practice that before Election Day, it's a different sort of standard. It's always been the case. And as I mentioned, there are cases from 1865, from the early 20th century, where federal candidates challenged electoral practices, and it was completely uneventful that they were allowed to hear their case, or that federal courts were allowed to hear their case. And so this is nothing new. There are no floodgates. There's no destabilizing. There will probably be some frivolous lawsuits, but courts are perfectly equipped with throwing those out. There have always been frivolous lawsuits as well. So this basically just returns us to 2019. And so, no, I just have to say respectfully disagree with that.
Yeah, even Justice Coney Barrett and Elena Kagan also kind of pointed to the fact they thought maybe it was too broad in scope, but they ultimately agreed with the overall premise here.
Correct. Yeah. So we won 7-2. Now, two of those people two of the seven sort of disagreed on maybe how broad or how narrow it should be. I think that's the sort of disagreement is more in theory and not really practice. You'll have a lot of overlap between those two, the competing views between the 5 and the 2. But Justice Kagan agreed with us. It was clear she agreed with us at oral argument. It's really not eventful, right? If you spend money to run as a candidate, you have the ability to raise legitimate claims about electoral practices, and so it should be. There's not really that much daylight between the 2 and the 5. The 2 being Justice Barrett and Justice Kagan.
Yeah, and speaking of candidates spending money, one of the things that I was just kind of reading up that the Representative Bost said was, at the very least, the extended period of time where ballots are being counted means he has to continue to pay for, even if you should lose, you would or think you might be losing as these votes are being counted. You kind of have to continue to pay for your staff just in case.
Yeah, it'd be malpractice to close up shop the night of election. You still got 2 weeks of ballots coming in, right? And so, you can't sue over everything in federal court simply because you don't like something, right? You can't go sue because you hate how high your taxes are. You have to have something unique to you. And the Supreme Court today made clear that candidates are in a unique position because they're regulated in the competition for elections, and it just simply costs money. It's not complicated, right? In federal law, if something costs you a couple extra bucks, you typically get into court. And so, obviously with a sophisticated congressional campaign, Congressman Bost is spending lots of money. He's relying on a lot of volunteer efforts. He has to pay advisors to continue to monitor things. His district covers 34 counties. 34 counties. So he has to have a set of people to go visit and monitor the activity going on in 34 counties. Now, I haven't done the full survey on this, but I'd be hard-pressed to find any congressional district with more than 34 counties. And so he is uniquely burdened. He's been a great advocate, and he's been a great client to work with. And, we're really looking forward to the opportunity to frankly, to make to help the American public get back to some normalcy and bring the Election Day to a conclusion on Election Day.
And if people weren't following along with this entire story, just take us quickly back to the beginning and how we ended up here at the Supreme Court.
Sure. So federal electors in Illinois, we first brought suit in 2022 in federal court. Chicago area. And so we appealed this, and we went to the Seventh Circuit, which is the intermediate federal appellate court. They too disagreed with us, but there was a split amongst the judges as to whether or not we should. One judge at least said they thought we should be able to have our case heard in federal court. And so we asked the Supreme Court to consider the case. They granted cert, which means they agreed to hear the case in the summer, and it was one of the first cases it heard this fall. And one of the first cases it ruled on. We were actually thinking it might come out today because really it's not a controversial issue. People report it as a controversial issue. It is not.
All right. Thank you so much. We'll end the discussion there. Appreciate your time here today.
For having me.
All right.
Thanks for watching Fox 32 Chicago. Subscribe now for the stories that matter and never miss what's next.